the ban of the Volume 1 or Volume A. Where we talk about the context. And I want to preface this by saying that everything I'm going to say here is not disputed. The only thing that's disputed, which is not important in what I'm going to say, is that the Zondo Commission did not produce any tangible results. Otherwise, all this is effectively common cause. This is what it says in the affidavit of Dr. Hlophe. If true, these allegations, which include the judiciary for the first time, represent unprecedented levels of real state capture. They exceed by far anything which was previously dealt with in the so-called Zondo Commission on State Capture. That context is crucial in this application. And then he says in the next paragraph, the so-called Zondo Commission, which was dealing with narrower issues, lasted for approximately 4 years. And cost the taxpayer an estimated 1 to 2 billion rand with no tangible benefits. And that's so we can write that off because that's disputed. We'll deal with it later. I'm just doing the introduction. The last sentence is very important. We say, it is largely responsible for the present public fatigue and skepticism about commissions of inquiry and their utility. And I want to start there for a reason. So we all agree that this proposed commission is going to deal with wider issues than the Zondo Commission on State Capture, in the sense explained there. We all agree that that commission lasted for 4 years and cost the taxpayer between 1 and 2 billion. And one can extrapolate that this one will cost at least that or more. And we also all agree that the public is tired or sick and tired of commissions of inquiry and their utility and skeptical about their utility. The reason I'm starting there is because this is the backdrop against which the impugned decisions have been taken. The purported reason, actually the only reason given in the announcement made by the President for placing Minister Mnchunu on leave was to make the commission to be more effective, or words to that effect. I'll come to that in detail right now. And a generous interpretation of the leave of absence decision would be that, because we asked the rhetorical question, leave of absence pending what? And supposedly the most generous answer that one could give is that it's pending the commission. So the commission becomes central. Now, we would like to then move on to the issue of, which is going to be central to this matter. That's the issue of the leave of absence. Why is that central? Remember the issue about the interplay between the decisions. So that decision is central in the sense that in relation to the acting minister stroke Kachalia decision, it is purportedly, well, put it this way, there would have been no need to appoint acting minister Kachalia if the leave of absence decision had not been taken. Or, to put it differently, had that decision not been taken, then the president would have been free to appoint Professor Kachelia as a minister. That's self-evident. So that's the centrality of that decision. On the other hand, as I've already said, its relationship to the commission is that presumably, my learned friends I'm sure are going to argue this, presumably the leave of absence decision is pending the commission. We will go as far as to say, Justices, that if we are correct that the President, and we are convinced that we are correct on this, does not have the constitutional power to place a minister on leave of absence. If we're correct, for a minute, let's just assume we're correct on that. If we're correct on that, then the question as to whether that decision, once it was taken, was rational or not rational, does not even arise. Because if it's ultra-virus, it's ultra-virus. It doesn't matter whether it's rational or not rational. And if we're correct in that decision, as I say, then the second decision on the appointment of the acting minister also must fall together with it. Now, that is the canvas against which we're going to approach this matter. The next point which I'd like to highlight is that obviously at the back of all this is legality. But we are going to talk about legality in three dimensions. Let me put it that way. And I'll use some shorthand that I know this court is familiar with. So we talk about illegality in the third shore sense. What do I mean by the third shore sense? And I'm paraphrasing. We all know that the third shore decision is a pivotal decision which says that the executive, including the president, or any functionary for that matter, may only exercise powers conferred on them by the Constitution or legislation or by law. Once you stray outside of what is conferred on you by law, in other words, unlike a human being, you can't just do what you think is right or what looks, you must do that which you are empowered to do. And then there's legality in what we call the Albert sense. And that is the rationality, the standard of rationality, which says that there must be a connection between the means and the ends. And all the cases, pharmaceutical, Albert, and so on. Then there's an area of legality which is probably neglected, which was articulated, I think it's paragraph 3 of the Law Society case, Law Society versus the President, which says that a fatally tainted process renders the decision irrational. And this is what is said in that paragraph. Our president is never at large to exercise power that has not been duly assigned. So that's a rehash of the Fetcho statement. And then Mogoeng CJ went on to say, crucially, public power must always be exercised within constitutional bounds and in the best interests of all our people. Always we talk about this rationality in these dry technical terms. But that qualification, that for it to be rational, it must also be in the best interest of our people, is often forgotten. And in the context of this case, that raises a few rhetorical questions. Is it in the best interest of our people that we have yet another multi-billion commission which may or may not yield any outcomes? So that, as I will demonstrate, the community and the public can be sanitized and numbed into forgetting. By the time the commission report comes in 3-4 years' time, everyone would have forgotten what the issues are. Is that in the best interest of our people? Is it in the best interest of our people to have 2 ministers holding effectively the same portfolio, being paid over the next 3-4 years, 2 salaries, one sitting at home doing nothing, the other one acting in his place? Can that ever conceivably be in the best interest of our people? And more closer to home, is it in the best interest of the people to have the president doing all these maneuvers of this one is acting, this one is now acting in the place of the one who's acting, to the extent that as we're standing here now, we have 3 ministers of police. One in his absence, in the leave of absence, the other one acting in the place of the acting one. Can that ever conceivably be in the best interest of our people? Is that's what the people want? On top of the already bloated cabinet that is already there. And is it in the best interest to treat the same situations differently? And I'm being generous here. To know, one day, as the decision maker, that you are at large to dismiss a Deputy Minister Whitfield for merely going overseas without permission. Assume that is such a bad thing. But the following day, you don't know that. Suddenly you say, no, I can't. How could I ever dismiss a minister on untested allegations? Is that in the best interest? That a person given so much power as a president, and this court explained in the EFF1 case, the enormous power that is wielded by a president in South Africa. That a person with that much power should be allowed to do that, to amplify that power illegally, as we are going to demonstrate. Now, let me just pause there. I'll come back to the merits. I want to deal very quickly with the preliminary points. In my understanding, well, if judging by the heads and the practice note of the other side, the issue of urgency is not contested. Certainly not contested by Minister Mnchunu. And it is kind of half-heartedly contested by the President in the papers and linked to the so-called prematurity point. So the real preliminary point is exclusive jurisdiction. Now, I just want to say this. Again, if you look at the papers, you'll notice that the opposition to exclusive jurisdiction is really, as I say, not so vigorous. But it's very rigorous in the heads for understandable reasons. I would also spend 18 pages on exclusive jurisdiction if I had a case like the other side has. But the issue is very simple. The issue is this. What are the president-specific or so-called agent-specific obligations that are at play in this matter. And I want to say this up front. The fact that those agent-specific and president-specific obligations might be mixed up with other general obligations is neither here nor there. Because I'll be the first one to accept, for example, that the obligations that are in Section 96 of the Constitution are not only assigned to the President, but to all members of the Cabinet, including the President. But the test is simply that we're talking about the Chapter 5 obligations. Nobody in their right mind can debate the fact that to the extent that there are obligations in Chapter 5, those are President-specific obligations, because after all, that chapter is called the President, or at least the first parts, and to the extent that he appoints the Cabinet, that must be read within the context of Section 85. 85.1 says that all the executive power is vested on the President. And then, of course, he has the right to get assistance, to put it colloquially. Now, here's the fallacy of the argument on jurisdiction from the other side. They seek to read too much into the fact that some of those obligations are coupled with discretionary powers. But I'll demonstrate that that's completely, that's really just gilding the lily. The issue is this, and I'll just take one example. So the power says you may dismiss. No, let me take the Section 98 example. The power there says you may, and I'm paraphrasing, you may appoint a cabinet minister to act in the stead of another one. Now, the other side would like us to believe that because that power is expressed as you may assign those powers to the acting, therefore, well, that's the end of it. That means it's a discretionary power. There's no obligation or duty. But that's fallacious logic. Our courts have said many times that you may have a discretionary power, but within it embeds duties. Let me explain that using the same Section 98. So it might be discretionary to appoint an acting minister or not. In other words, you may decide not to appoint an acting minister. But once you have taken that decision, then you have a duty to appoint a cabinet minister. Right? So you can't be mesmerized by the fact that there's a word may in that sentence. Because once you've now chosen that, and the example I was giving to my juniors was, well, I have an option to go on holiday overseas or in South Africa. But once I've decided to make the decision to go overseas, then I must have a passport. I now have a duty. So the fact that the first decision was optional does not negate the duty that is embedded. Now, once that is understood, then the entire attack on exclusive jurisdiction must fall away. Because self-evidently, those duties are on the President, let alone the fact that they are now coupled with Section 83B duties, which are clearly the presidential powers. Let alone the fact that they are also traced on the presidential oath of office. And I'm sure my learned friends, whatever they're going to say, they're not going to say that the duties that arise from the presidential oath of office are not specifically assigned to the president, only as an agent. So that should be the end of that. This case, with the greatest respect, is even stronger on the issue of exclusive jurisdiction than EFF1. Because you'll remember in EFF1, there was Section 83 obligation to anchor, but it was then coupled with, I think, Section 182, which was the power or rather the duty to obey remedial action. So in a way, you had two weak rights combining to give exclusive jurisdiction. Here you have two strong rights emanating from 83, rights emanating from 92, rights emanating from 98, rather duties or obligations from 98, and also from the oath of office. If we're wrong about that, then clearly this is a case that cries out for direct access, because nobody in this country is going to be able sustainably to say that this is a matter which must, traverse the entire distance to the High Court and to the Supreme Court of Appeal, and one day in 5 years' time come here. That, again, my learned friends are not going to suggest that. Let alone the cynical problem in that proposition, which is that not only must the public be paying for another 3 or 5 years 2 salaries for 2 ministers, but it must also pay for litigation in the High Court, in the SCA, and so on, just for the matter to be resolved. That's only an insensitive person can suggest that is what should happen. So before my free time is gone, I want to go back to the issues on the merits, and I'm going to, as crisply as possible, just outline on each topic what we say are the constitutional problems. Topic 1 is the leave of absence. As far as the leave of absence is concerned, justices, we say the following. As I've already said, the president does not have the power to place a minister on leave of absence, full stop. All the parties, fortunately, agree that there is no such express power, that nobody has to go there. So the best case for the other side would be to rely on some kind of implied power, because we all agree that it's not there. If it was, we would all see it. And we will demonstrate that on the test put by this case, rather by this court with respect, in Amabungane by Madlanga J, and as complemented in Mwabe by Majid J. On that test, which in any event is an accepted test, the test of necessity, you cannot have an implied power unless that power is necessary to exercise the one that is primary. That's just as simple as that. Sorry. If I may, just express that proposition. Hoekstra, in the latest book on admin law, expresses the test of necessity beautifully as following. Starts by re-expressing feature. It's consonant with the principle that repositories of power can only exercise such power as has been conferred on them by law. Implied powers may, however, be ancillary to the express power or exist as a necessary, and that's where the test is, or reasonable consequence of the express power. And this is the beautiful example she gives. Just as the power to make omelets must necessarily include a power to break eggs, so the power to build a dam may include the power to expropriate property or to remove silt. And then she makes other examples. In other words, for an implied power to arise, it must be a necessary concomitant of the primary power, the one that has been expressed. So how do we bring that home here? You would have to find a formulation, absurd as this might sound, that says that the power to dismiss, for the power to dismiss to exist, it is necessary in the legal sense that you must also have the power to place a minister on leave of absence. Ha.
The clock there's the clock, Mr.
Thank you.
Thank you.
Well, it seems like your clock moves faster than mine.
You'll have to take it for
Yes.
that one.
Thank
Mr. Mpofu, let's just deal with the last point.
This point on
One that
implied
I
powers.
raised.
Yes. Thank